Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing employment law and side hustles. Many people have a second side gig on top of their regular day job. But what should you expect if your side hustle is on the spicy side, like if you make extra income from an X rated OnlyFans account, or if your side hustle is sexy modeling? How might this type of side hustle impact your day job? And what risks do you face if your employer doesn't like it? As well as what should employers know about these types of issues? If one of your employees has an OnlyFans page, what impact could it have on your business? Here today to discuss this issue is employment law expert Mackenzie Irwin. Mackenzie, thank you so much for joining me for this conversation today. First of all, what do you think people should know about having any side hustle at all, let alone one on the spicier, sexier side? This is sometimes called moonlighting, and I know that it can be prohibited in some employment law contracts, but what should people know about this type of second job?
Yeah, so I mean, definitely with this economy, it's more and more popular that people are taking on extra side work, taking on another side hustle, side gigs. But in general, Canadian employment law doesn't specifically prohibit employees from working two jobs or carrying on a side business. However, employers, they can do employees can do anything, including having a second job. They are not allowed to do anything that is contrary to their employer's best interest. So this means, some employees won't be able to really work for a competitor if they have that side gig, or their side gig can't have them engaging in something that would cause their main employer some sort of embarrassment or loss of business. So it really comes down to the harm it may cause to your main employer. So employers, on the other hand, they can prohibit moonlighting by specifically stating that it's prohibited in, let's say, an employment contract with your employee or any kind of employee code of conduct. That's something that we call an exclusivity agreement. And these agreements, they prevent your staff from working for another company until their employment with you comes to an end. So there's many ways that employers can limit your extracurricular work. They can do that through non-competitions and non-solicitation clauses in your agreement. Those are ways that employers can limit what you do outside, even after you've been fired. Those agreements can still be in effect. So this really just highlights the importance of reviewing an employment agreement and an employment offer in detail before you sign it. So if you're someone who already has some sort of side gig going on, or you're looking to supplement your income with a side gig, you're going to want to really look into your contract, make sure that those terms aren't there, and that side gig won't be violating any of those terms. And if they are, you're going to want to be negotiating those terms if you intend to keep carrying on that side gig. So it may mean that if you're accepting these terms, that you would have to give up your side gig. And that might mean actually looking into maybe negotiating an increased salary to compensate you for having to give up that side gig. So all things that are really very important in employment law and very, very active right now. We're having a lot of people come in with issues, employers and employees, having issues with employees engaging in these side gig activities and what to do with that.
So there's kind of two big issues that I think come out of what I'm thinking about from what you're saying. The first is types of behavior that could be contrary to the interests of the employer, types of conduct that could be embarrassing to the employer, and then what's actually in the contract, what counts as moonlighting. Just very briefly, we've only got about 30 seconds. What types of things count as moonlighting? Does it matter if you're just, maybe starting out a little business and you're not making money yet? Would that still qualify as moonlighting under an employment law contract?
Yeah, so even if you're not making money yet, the fact that you're engaging in these activities, trying to set up a side gig, a side company, That's something that certainly, as long as it has an impact on your employer and that company's it has that company's reputation,
Right.
if it has the
Right.
potential
We we've got to
to
go to
harm
break,
them,
but
then
we'll be right back. Welcome back to Canadian Justice, where we're discussing employment law and side hustles, including when those side hustles are on the spicier side, like X-rated OnlyFans accounts. Now, Mackenzie, in the last segment, we were talking about the difference between off-duty conduct or moonlighting that might be prohibited because it's prohibited in the employment contract, and then off-duty conduct that might cause the employer reputational harm or business harm, and both can be prohibited in different ways by your employer. What did you want to say about that?
yeah, so you're right. It comes from two different bases. There's what's in your contract and what's in your company's policies. Some companies may have specific policies that say you cannot engage in any outside activity or place limits on certain activities that you are not allowed to do. But even if your contract or your policies are silent on these issues, there still is a right. Your employer still has an interest in protecting their public image. And so if you're currently working and employed for a certain company and your side gig has the potential to cause your main employer harm, whether that's reputational damage, embarrassment, loss of business, then you're running into an issue, and there's likely a general issue that you would have with your employer if you're going to engage in those side gigs.
Now, I think that this is where things get squishy and the idea of what might cause an employer embarrassment. So I I think it can depend on the nature of the job, right? I can see the argument for schools saying, our teachers, if they were to have an X-rated OnlyFans page, that could cause harm to to the school board, to the school itself, and potentially to be very disruptive in the classroom. But in other business settings, I'm not quite as convinced. And maybe let's take a less spicy example. What if you just are engaged in modeling or cabaret dancing, and your main day job is you're a welder, sort of a modern day flash dance example. So how is it determined what would cause this reputational harm to the business or embarrassment to the business, especially in a society where values and norms about what's appropriate to post on social media, about the normalization of sex work itself, how when those are changing, what is the line for what causes that harm or embarrassment?
And I think that's a really, really tricky question to answer because it's going to depend. It's going to depend on what your role is in the company, what the nature of your industry is. Those are all factors that are going to contribute to whether the activity that you're engaging in is going to cause your employer any kind of harm. So loss of business or embarrassment. So that's the real main question that we're trying to come down to. Is it going to cause your company harm? And there's no hard and fast answer to it. There's no line to draw in the sand. It's really going to be situation dependent. So, for example, if you're an executive who's in a very prominent client-facing role, and you have a OnlyFans account, that's going to be a problem for your employer, and that can cause pretty obvious harm to their business. On the other hand, if the employer, let's say the employee is working in the mailroom, it's unlikely that it's going to be as much of an issue for that employer. So it's only one factor that's going into determine whether your employer, whether a breach of this, whether this activity is going to be something that they can rely on to terminate you for cause. But it's certainly something that does play into the equation and will certainly be a bigger factor in terms of whether your activity is going to be causing that harm to your company.
So let's use your mailroom example. Say that the mailroom employee does have an account like this with some X-rated images, and that's their side hustle, and the company's okay with it. Does the company, if the company's aware of it and they are fine with it, do they have any obligation to, I can see how this could cause issues in the workplace related to sexual harassment. Does the company have any obligation, if they're okay with this off-duty conduct, to ensure that the employee is not subject to harassment by their colleagues?
Absolutely. So all employers have a legal obligation to protect their employees and prevent harassment in the workplace. So regardless of what the root cause of that harassment or bullying is, whether it's in office or off duty conduct that is the root of the harassment.
Welcome back to Canadian Justice, where we're discussing employment law and side hustles, including what to do if your side hustle or your employee's side hustle is on the spicier side. So, Mackenzie, we've talked about how your employer might be able to take action against you as an employee if the side hustle, including a spicy side hustle, is causing reputational harm. But for the most part, people who have these sexier Instagram pages or OnlyFans accounts aren't saying their day job employer on the bio. Like, people might not connect it automatically with the normal employer. And to go even further, a lot of these accounts don't even show faces, and some of them are not even necessarily X-rated. They are just maybe a little weird, right? And like, I'm thinking these feet pictures, right? So if you were posting something like that, no faces, no identification for the employer, is there still a way that your employer could find out and raise concerns that it's causing them reputational harm, even though there's no connection either to you or to the employer?
Yeah. So, I mean, the risk is always there that your identity and your employer can be exposed. The internet is pretty vast and it's forever. So it's incredible what can be dug up on the internet. So I think that's a lesson that we're learning time and time again. But, legally speaking, the connection can always be made. And if, regardless of whether your employer approves or not, the real question is it going to cause your employer harm? So again, this is something that there's no hard and fast line, but as long as your employer is free to terminate your employment uh, based on these extra or off-duty side gig engagements. But I think the real question is, would your employer have just cause to terminate your employment in those situations? So in the vast majority of these cases, I don't think that that these engagements would rise to the level of just cause. But that doesn't prevent your employer. Your employer always has the right to terminate you as long as they're providing you with proper severance and they're not violating any of your human rights. So it's something that you're going to have to think about before you engage in these side gigs or side hustles. And you're going to want to make sure that you're not offside in any kind of employment agreement or company policy, regardless of whether your name is posted on it.
So, Mackenzie, if an employer finds out that their employee is engaging in one of these side gigs and maybe one on the spicier side, how do they approach their employee if they don't want them doing it? Because I'm sure it is a sensitive issue. It might be potentially embarrassing for the employee. They might feel uncomfortable that their employer found out. And of course, I think that there's probably steps involved. The employer shouldn't just come right out the gate gunning for termination. What approach do you think they should take here?
Yeah, so this is a very sensitive territory, and you're going to want to make sure that you're approaching the situation sensitively and with proper advice. So, my advice is to speak with an employment lawyer the second that you find out, because we're going to be able to help ensure that you're dealing with this in the proper manner. So, At the outset, I would say that employers need to make sure that they have the proper policies in place so that they have something to point to say, this is in violation of this policy. Um, you're going to want to approach the employee and politely and discreetly request that they stop or remove the content, particularly if this content is harming your business or causing the business any kind of embarrassment or publicity. You're going to need to provide the employee with a timeline for when the company expects all of the accounts to be taken down, and you want to make sure that the employee knows that their conduct is in violation of the policy and give them the opportunity to correct that behavior. If the employee refuses to cooperate, it may mean that the employer will need to let that employee go. And again, with the advice of an employment lawyer, we can ensure that you're conducting a termination properly. We can determine whether you have grounds to assert just cause, and if not, to advise you on what the proper severance entitlements would be. It's important because failing to properly do this and do this in a sensitive and calculated manner could expose the company to some sort of wrongful dismissal suit. But on top of that, additional damages for the
Right.
bad faith or perhaps human
Right.
rights violations.
Welcome back to Canadian Justice, where we're discussing employment law and side gigs, especially what to do if your employee's side gig is on the spicier side. Now, Mackenzie, how much of this type of thing are you seeing in your practice as an employment lawyer? I'm especially interested in how often there's this conflict between the employer and the employee over the off-duty conduct or the side gig. And I'm also curious how often that conduct falls into the bucket we've been discussing today, moonlighting in a role that is a little too spicy for an employer. What's your experience been like in practice?
Yeah, so we definitely see a lot of these kinds of situations where the employer is mishandling, either disciplining an employee for off-duty conduct or improperly terminating them for cause, or failing to protect an employee who's being bullied or harassed for off-duty conduct, but the bullying and harassment is taking place in the workplace. So with the state of the economy, more and more employees are doing and supplementing their incomes with these side gigs, whether it's driving Uber or doing some sort of delivery service at night. Those aren't really ones that tend to be too concerned about. It is usually these spicier, um, more dramatic side gigs that employers are taking issue with for obvious reasons, and those are the side gigs that tend to cause employers more harm. So those are the ones that they're interested in, they're concerned about, they want to take action on. It's not so much the Uber driving on the weekends. So as employers are becoming increasingly aware of their employees' social media presence and their efforts to supplement their income, they need to take action to clarify what isn't acceptable in the workplace through updating their policies. So we have a lot of employers who are reaching out to update those policies to make sure that they're really covering themselves if this situation were to arise. But I think we're certainly going to be seeing many more of these kinds of cases as this trend increases and as employees are experiencing consequences for their efforts to supplement their income.
Now, if someone wants to start a side gig, what kind of advice, a side gig of any kind, what advice do you have about it? And I'm particularly interested in this issue of, a lot of people think I can just do this and my employer's not going to notice and they're not going to find out. First, what do you have to say about that? And what do you have to say more generally about starting any type of moonlighting side gig?
Yeah, so if you're already employed and you're thinking of supplementing your income with some sort of side gig, my first piece of advice is double and triple check your workplace policies and contracts to make sure that you understand what your employer does and does not permit. You want to make sure that you're on side with your obligations to your employer, um, a- and that's step one. Next step is if there's no policies in place, your contract silent on these things. You're going to want to make sure that you're double checking that this is something that's not going to cause my employer any harm. This side gig isn't going to cause them any embarrassment. You don't want to be starting something and behind your employer's back, trying to supplement your income that may jeopardize your main source of income, your main job. Because the reality is, employers are permitted to terminate employees at any time, as long as, for any reason, as long as they're not violating your human rights and as long as they're providing you with proper severance. So you want to it's important that if you're looking to start a side gig that you're cognizant of that fact, and if there's an issue, this is something that may jeopardize your current employment.
Yeah, and I think the notion that your employer will not find out. I mean, you can find almost anything on the internet, and I think that people are shocked by how quickly that their colleagues are able to uncover really old pictures or things that they thought no one would ever see. So, Mackenzie, thank you so much for joining today. This has been a great conversation.
Thanks so much for having me.
We've heard today about employment law and the impacts a spicy side hustle may have on your day job. Any moonlighting can have an impact on your employment relationship, spicy or not. And off duty conduct can sometimes damage the reputation of your employer. How will you get the balance right if you want to start a side gig, spicy or otherwise? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.